Welcome to Superyacht Radio. We have the pleasure of being joined this morning with Ian Flockhart. Or good afternoon or good evening, wherever you are in the world.
Captain Ian Flockhart. He's worked hard for that title. You can't dismiss it. Capitan.
Anyhow, lovely to have you here today.
As always.
As always, you have become our font of knowledge. I have to tell you, I have learned a lot in our chats over the past couple of weeks. And this morning I'm going to be learning something more because we're going to be talking about contracts.
Yes, we are.
The amount of captains that I bump into who are in that kind of nasty stage of fighting for getting paid because they haven't bothered doing a contract, and they get on a boat and they go, oh yeah, well the captain said he'll do it in a week, and they just don't get around to it.
Yeah, it happens a lot, and I'm in that same situation. I'm in the middle of a 2.5 year legal battle. I did have a contract, but there's a lot of complexities in my own case, and I'm going to mention one of them in particular later on because it might help other people prevent from ending up in the situation that I'm currently in. First thing I'd like to say, a little bit of a disclaimer: I'm clearly not a lawyer, and anything that I'm saying is basically just based on general advice, based on many years of personal experience, and it is very sensible if ever you feel the need for legal advice to go and contact a competent and experienced lawyer who specialises, and this is to be noted, in the specific aspect of law that you're concerned about, and importantly, very relevant to yachts, in the relevant jurisdiction.
In the relevant jurisdiction?
As
in the difference between a super yacht versus a yacht, or where you are in the world?
No, the legal jurisdiction, as in which court is going to be dealing with it. We'll get onto that a bit later because I've got a scenario where that sort of looks at jurisdictions, and it's very, very important. But we'll come on to that.
So, where to begin? I mean, contracts in any industry are vitally important, and checking you dot your I's and cross your T's are an important part of it. I presume
I think so.
There is a standard contract that most people see and they skim through when starting a job.
I think that does happen. I think what we ought to do is let's first look at what a contract is. I think that's quite important in itself. A contract is a written or spoken, be cautious of that, agreement between two or more parties that is intended to be enforceable by law. That's a very important point because, if you're going to make an agreement, it has to be something that you understand can be enforced in law if necessary. So they exist to set out terms to ensure that each party's obligations and responsibilities are clearly understood. There's four main sections to a contract, certainly under the UK jurisdictions, and this is any kind of contract, not necessarily just an employment contract, but they're applicable anyway. The first is that there must be an offer, there must then be acceptance, there must be consideration, which usually comes in the form of financial consideration, but not always, and there must be intent. That means that the parties making the agreement must actually have genuine intent to carry out their respective parts of the agreement. Again, we'll come to that later because that's quite important as well, that crew members and captains must also remember that they have a responsibility to fulfill their side of whatever agreement is entered into. So that's very basically what a contract is, the purpose of a contract. We have in the maritime world over the last few years MLC, SEAs, Seafarers Employment Agreements, which we'll go on to talk about. In terms of the importance of a contract, I'm sure we've all personally experienced or heard stories of the captains of crews that end up chasing employers, money, etc.
Sorry about that. We're just pausing, Ian, for one moment.
Yeah, go ahead.
Sorry, there was a slight pause. Please continue.
Okay, all right. One of the most common things to consider why it is so important to to have a contract is that yacht owners frequently hide behind quite complex ownership structures. One of the purposes of that is to minimise their own exposure to litigation. So, for example, in the event of a wages dispute, you're almost always taking on a separate corporate entity rather than the actual owner of the yacht. If you find yourself in a situation like that, you'll often find that corporate entity is little more than a brass plaque on the wall of a wooden hut with a corrugated iron roof somewhere in a remote South Pacific island. And more importantly, that entity may well not have any tangible assets from which you can recover any claim against them. So that's an important thing to bear in mind as well.
Double check who you're signing the contract actually with.
That's difficult, though.
We'll get into this when this is jurisdiction is important, but oft times, particularly when the boats get larger, you will be employed by some completely separate entity, and that may not even be the owner of the vessel at all. By that I mean the beneficial owner or the legal owner of the vessel. It could be a company that's set up specifically
Cayman Islands holding company,
and they're very often yes, they exist as legal entities, but they're very often virtually have no assets whatsoever. They're there simply to perform a function.
So is there any way you can kind of when you're looking at it, you can ask who am I actually signing with?
Well, that will be clear once you get a contract put in front of you, because the name of the employer must be in a seafarer's employment agreement. But also, and this is quite important, if the ship is not owned, if you are not being employed by the ship owner. Now, by that we mean in most cases that will be the entity that owns the ship, not the actual beneficial owner. Then the employer is legally obliged to enter into the seafarer's agreement the name and address of the actual ship owner, which will be
of the actual person or the company that owns the boat.
It'll be whoever owns the vessel, and in the vast majority of cases, that is not a private individual. It is some kind of corporate entity.
So whoever or whatever owns the boat.
Yeah, it will be whoever in the terms of a legal entity. Some company that's set up that. So that information must be in an SCA. If it's not actually, if you're not employed by the ship owner directly, so if you're employed by a company that's set up, just to manage payroll, etc., then that information has to be in the SCA.
Would it be safe to assume then that the average seafarer who's taking a job on a boat, who's presented with a contract, if you were to investigate who you're actually signing the contract with, what that entity is, you could be looking at quite an in-depth search in trying to find where that company is. Does it have assets? I mean, the due diligence.
You could be, yeah. You could be.
Would be a job in itself, I would imagine.
Yeah, and frequently they do not have significant assets. It depends on how big an operation it is, how smoothly they operate, etc. But frequently they do not have a great deal of assets behind them, and that's very often quite deliberate.
So, for example, I could own a boat, and I might own it under ABC Limited, and that's the owner of the boat. However, I may have a separate company that's set up the Channel Islands or Guernsey or whatever, and its only function is as the employer. And that entity necessarily has no assets. It doesn't own the boat as such, so it doesn't have that boat as an asset. Yeah. It's purely an off-the-shelf company, and its only function is as a vehicle to employ the crew of the yacht.
Yeah, and I can attest to that through bitter experience.
I was getting that feeling.
So that can be the case. So that's something to be cautious of. But it is kind of difficult to,
there's nothing you can do about
protect
that,
yourself.
There?
There's very little you can do about it. There's very little you can do about it.
You're signing on good faith.
this is one of the reasons why the MLC introduced the Seafarers Employment Agreement. It would probably be sensible if we don't go any further without talking about that, because it really is quite important. Just a bit of sort of general background knowledge there. Crew members working on board vessel are governed by whatever the contract of employment they have that's been agreed, and by, in certain circumstances, wider applicable law. The law of the yacht's flag state technically regulates employment on board, but local port states can also have an influence on that if you've got, say, for example, if you've got an aggrieved crew member that's seeking some kind of redress. Another thing that happened with the SCAs that was a little bit unusual was captains never used to be signed on to the old-fashioned crew agreements, because they were sort of deemed to be somewhere in limbo between the employer and the crew. But captains now should also have seafarers employment agreements as well, which is probably a good thing for the captains.
What do they have before? Just a handshake?
Well, no, you would have well, in some cases, yes, but you would negotiate a contract directly with the employer. But the captains were not signed on to the crew agreement previously, because it's a historical thing. It goes way back to when captains were deemed to be kind of in cahoots with the ship owners themselves,
the owners
and were therefore not. Yeah, they were therefore sort of not impartial, and that's. I mean, it goes back 300 years or whatever.
Back to the old trading days when the captain would crew up a ship and
exactly, okay. And he would be, he would not be considered to be impartial. He would be, he was basically considered to be on the side of the owner. Okay. Another thing that's important to remember is that the MLC is not in itself per se a statement of law. Right? What it is, it's a set of rules which the countries that are party to the MLC, the ratifying countries, agreed to incorporate within their own system of laws. Okay, so you must turn to the specific flag state laws to actually deal with any instances that come up as a result of this. So the MLC in itself is merely a set of rules that a group of countries that have ratified the agreement have agreed to incorporate into their own sort of statutes.
But they're not necessarily the same throughout the world.
No, because each flag state has the privilege of making its own things, as long as they're generally compliant with, presuming it is ratified with the MLC, that it's in general compliance with the philosophy of what's contained within the MLC.
Sorry, Ian, could I ask you, just for clarification, we do contracts, we enter into contractual agreements with people who advertise or work with us commercially, and throughout my life I'm no stranger to contracts. Typically in a contract, as you alluded to earlier on, you've got your different clauses and setting out the detail of it. But usually there's a clause in there as to the jurisdiction that contract falls under. So if there's litigation or if there's a problem with the contract, we've predefined the jurisdiction, be it England, Luxembourg, or whatever. In the situation with the boat, you're saying the flag state weighs heavily on it. So in the contract, in the SEA, would you typically have a clause that this contract is subject to British law or Cayman Islands law or Hong Kong law? And if so, how does that fare with the flag state of the boat? Is there mutual exclusivity? Does one take legal precedence over another? And I do appreciate you're not a lawyer, so don't mean to put you on the spot with that, but does my question make sense?
It does. I mean, if we can jump forward to a bit that I was going to come to a bit further on.
Okay.
I've been in a situation before, and the names of the countries here are purely just made up just for the purpose of discussion. But you could, for example, let's say you're on all the crew are on vessel of a flag that's registered in St. Vincent. When that vessel is in international waters, they are standing in St. Vincent no matter where it is. Okay, they're also standing in St. Vincent no matter whether it's within territorial waters of another state as well. So if you've got a St. Vincent registered vessel and it's in the UAE, okay, depending on what the issue is, you are potentially subject to the law of one or other or both of those states. Okay, you're always in St. Vincent so long as you're on the vessel.
Okay.
But if, let's say, for example, a crime is committed and you're inside the territorial waters, a 12-mile limit of the UAE, right, then you've got them to have to deal with as well. Right. Now, to further complicate matters, you may have this vessel that's registered in St. Vincent. Owning company may be registered in the Marshall Islands. Okay.
Mm-hmm.
Your employment contract, maybe you're working for a Turkish owner, could be under Turkish law.
Wow.
And you're
It
in
can get
the
very
UAE.
complicated.
Back to why you need a good maritime lawyer if you have a
You're in
problem.
St. Vincent and the UAE at the same time. Yeah, it can become very complicated on ships. And this is why, I stressed at the beginning, if ever a captain or a crew member, really doesn't know what to do, they really need to get in touch with a competent lawyer that is familiar with whichever jurisdiction may be involved. Now, say, for example, something like that, you may contact a lawyer that's familiar with the flag state jurisdiction, but if it's an employment issue, you may also need to be dealing with someone who's familiar with Turkish jurisdiction, because that's where your contract is. If it's a criminal thing, then you also need to be talking to a lawyer who is familiar with UAE jurisdiction.
Right.
Okay.
So you may need more than one lawyer.
You may need more than one salary as well, because it's going to be expensive.
You may need more than one lawyer. Yeah, I mean, that's just a very hypothetical and complex situation. But I just did it to illustrate that it can be complex depending on the nature of the issue that requires legal attention. Yeah, if that makes sense.
It makes perfect sense.
Yeah. Okay. Just another couple of points, if we can just go back to SEAs again.
Can I show my ignorance? Sure. SEA stands for?
Seafarers Employment Agreement.
Okay.
Now, SEAs have to be approved by the flag state. Now, that means approved in a general term. The MCA, for example, have got a model format of a Seafarers Employment Agreement. And every single person that works on a boat should get online and download this and familiarize themselves with it, because that will be because the UK authorities have had such great influence in the world in many respects, and especially in yachting still under the whole Red Ensign group. What is laid down by the MCA is followed very closely by a lot of other jurisdictions. So if crew are familiar with the contents of the model SEA published by the MCA, then when they see something that deviates from that significantly, they will at least be aware of that. Now, employers are permitted to provide what's referred to as additional provisions to a seafarer's employee agreement. However, the flag state, or MCA specifically, will not per se review every employer's specific additional provisions that they make. However, any additional provisions that an employer wishes to make to an SCA must not conflict with, talking UK jurisdiction here again, UK general shipping regulations or any other international instruments that have been ratified by the UK. Okay, so if your crew member is familiar with what the MCA have published as a standard template, if you like, if they're then presented with something that varies considerably from that, then they're at least going to be aware of that, and they may be able to ask questions relating to these additional provisions that their employer are putting in if there's a major deviation from what the MCA have deemed as standard.
So know basically what the basic template is like, so you can notice the differences when you get your own.
You can go online, you can download it, you can see what the MCA have approved as the standard SEA, and if you see something that varies significantly or in any worrying way from that, then you need to start asking some questions.
Or something that conflicts with the basic MCA or
Well, exactly. We'll say the additional provisions, it says clearly they must not conflict with UK general shipping regulations or any other international instrument that has been ratified by the UK.
So crew are not allowed to sleep.
Exactly.
Yeah.
All things.
All things. Which is so true, actually, in some boats.
Another very important thing that has been entered into the sort of the rules surrounding the SCA. The number of people that I've met in my life that just sign a contract without reading it is just beyond belief. It states very clearly there's a marine guidance MGN 477 that covers SEAs, and again everybody should really download and read that. It's only a few pages long and it's critically important because it all relates to your employment contract. But you must be given the opportunity to review and seek advice on the contract that you've been given, and you must both the employee and the employer, ship owner, must sign the document to say that you have been given the opportunity to seek advice, and that you've received an explanation of your rights and responsibility under the agreement, and that the agreement is entered into freely. So that you're legally bound to give the employee the opportunity to properly review the document, and if they're not sure about anything, to seek further advice wherever they choose to do so before they actually sign the document.
How often do you think that actually happens?
I don't know, but I mean, I will sit and read, every bit of small print on anything I'm ever asked to sign. It doesn't matter how long it takes. I will sit and read the entire thing.
Well,
really, that is what people should do.
They should do.
I kind of want to ask, do you read manuals as well when you get something new?
Yeah, he's the
I
type.
generally don't, because these days products are so intuitive that you really shouldn't have to read the manual. We can design things so well now, and if they are well designed, you shouldn't even need a manual because it should be entirely intuitive.
Well, I think some of it is also maturity, because if you look at millennials and the younger crew, we are in a world where people enter into contracts several times a day without even, all they do is click I agree.
Yep.
The amount of, be it an app or be it Apple or Google or Facebook, nobody reads those contracts. And there's a mental conditioning there where people just accept, oh, there's a contract, where do I sign?
Yeah.
Yeah.
We've got. Let's be cautious mindful of this. I've actually got a sort of bullet point list that I want to run down before we finish the session. So if we if we're going to leave 10 minutes toward the end just to go over that. But there are a number of things mentioned there. The first one of the things on that list is any savvy employer is going to be organised, and they are going to send you a copy of the contract that they expect you to sign before you come to join the vessel, before they book a flight for you. Why would they waste money on a flight if you haven't even agreed to come and join the vessel yet, if you haven't seen the contract? Now, if an employer's not doing that, alarm bells should be ringing. Okay, you should have sight of your proposed contract before they buy you a ticket to go to the bar. Before you pack your bags. Okay, and that gives you the opportunity to do your own due diligence, go over it, go seek some professional advice if you need to have a better understanding of what's contained therein. And if you're not happy with that document, then don't sign it.
Because it's still, it's not going to hold up when you get there.
Exactly.
You're committing to something that you're not happy with.
Yep. Yeah. And if the organisation that's going to employ you isn't organised enough to have this done in advance and ready for you before you get, it'll all be all right when you get to the boat. Again, alarm bells should be ringing.
And I think possibly to add to that, particularly for young crew, is it's okay to come back and say, would you mind clarifying this point and this point in my contract before I sign it? Because for me, it doesn't seem clear. Do you mean this or do you mean that? And make sure
and get
black
that
and white
clarification in writing. Get that clarification in writing.
Not just a verbal. Yeah.
Not just verbal.
You got that. Okay.
Yeah. This, just at the very beginning, I mentioned in the definition of a contract can be verbal, but let me tell you, you're going to have a tremendous amount of difficulty defending that in a courtroom.
My dad used to say it's worth the paper it's written on.
Absolutely. And look, you might work for someone for 3 years and they paid you into a bank account for 3 years, but that isn't going to help you tremendously when you come to negotiate in a courtroom something to do with, say, for example, different clauses of your contract. Okay. The very fact that an employer has, paid for a ticket to you and brought you onto a boat, and they've paid you for 3 months even, right? That there's an implication there that you have been employed, and that's fine, and so long as nothing goes wrong. But As soon as things start to go wrong, then you're going to find yourself in a very tenuous situation that you're not going to be able to prove beyond reasonable doubt that your contract said you would get a 6-week bonus every year, or that you would actually get 60 calendar days leave or whatever, even though they may have done that and honoured it throughout the first 3 years of your employment. It's all good and well until something goes wrong. So your verbal contract doesn't really mean a great deal, because you're not going to be able to substantiate any of that once the lawyers get involved in it all.
Well, and the flip side of it as well is that it's not just the boat's responsibility to you, it's also your responsibility to the boat.
Yeah, very much so.
What you are saying, I will be there from, this time to this time. I accept these are my duties. You need to be clear what you are. I mean, I prefer the boat as well. They need the contract to make sure that the person they're getting in is signing up to do the job they need.
Yeah, it needs the contract. Our contracts should always be balanced. They should never favour one side or another. And, it's important to remember, we've mentioned this in previous discussions, that the employee also has responsibilities and obligations in that contract, and it's up to you to make sure that you fulfil them.
Yeah.
Just a couple of things just for people to be a little bit aware about in terms of contracts, things to look out for. Be aware of the jurisdiction of the contract. If your jurisdiction's under, say, English law, for example, then in most but not all cases, it's going to be relatively easy to deal with. Another thing to watch out for in contracts is the way that leave entitlement is calculated. There's a lot of boats out there that give crew members 30 calendar days leave, which, given how hard a lot of them work, I think is fairly unreasonable. So I would pay particular attention, especially if they're working, most weekends of the year as well.
I was going to say 30 days leave. Does that mean,
30 calendar days.
30 calendar days.
30 calendar days.
Not
that
working
is
days.
Presuming if I've just done 4 weeks on board and I've worked 7 days a week,
Yep.
Am I entitled to get those weekends back added onto my leave?
It seems that's not the case. That's why I'm saying be very careful about the way that leave is calculated in your contract, because when you look at the average hours that a lot of yacht crew work, and weekends, public holidays, whatever, it's to get only 30 days calendar leave for a lot of yacht crew is a bit on the unreasonable side, I think. So it's just something to be aware of.
Out of interest, ballpark, what would be, if you've done 3 months sort of full-on season, you really have only had a handful of days. What is a bit more reasonable to look for in calendar days? Because you can be working 7 days a week, which is different to the average job.
That's something that you really have to, if you're a captain, negotiate with your employer directly, or if you're a crew member, try and negotiate some kind of leeway with the captain on it, because it's a difficult situation. A lot of employers will just to default what laws say or regulation says. MLC says 2.5 days per month, just as if you were in a normal shore-based job, which is...
But that's including weekends.
Yeah, it's in many cases, it's I think it's very unreasonable given how hard a lot of crew.
If you're on a charter boat, a busy charter boat, they'll do the season here in the Med. Then in September, October, they'll go straight across and start doing the Caribbean season.
Well, that's what I'm thinking. Like the average person in the average 5-day-a-week job is still going to get 8 days in that month because they have weekend days, and then your bank holidays thrown in.
I mean, just as an example, I've never signed a contract that I've been handed by an employer. I've looked at them, I've gone through it with a fine-tooth comb, and I've said, no, that's not reasonable, that's not reasonable, that's not reasonable. And, you know, in most cases, it's all ended up, you know, I've negotiated a much more reasonable contract that's applicable to what you're bringing to the whole operation. It is harder for crew to do, though, because they don't have that, you know, direct clout to negotiate with an employer. So it's something that, you know, some captains will just be, a little bit more amenable to, you know, informal days off here and there, but it still doesn't constitute proper leave away from the boat. Public holidays is another thing. Look at what state's public holidays a boat is likely to give you, and, you know, do you get time off in lieu of those public holidays, which is, you know, a fairly common thing to do.
What about religious holidays? Is there much consideration for a person's religion and adherence to that?
Never been an issue for me, and it's never come up as an issue with anyone I've ever dealt with.
Just hire a godless crew.
Well, there you go. That's one way. Another thing I'd like to mention, and this is aimed predominantly at captains, but not only, because all crew members should do this as well. There exists a document called the Merchant Navy Code of Conduct, and I have for many, many years incorporated that entire document as an annex to an employment contract. Because what the Merchant Navy Code of Conduct does, first of all, it's approved by Nautilus, the UK Chamber of Shipping, and the RMT Union. What it does is it sets out all the, amongst other things, proper procedures that should be followed relating to all disciplinary matters on board. So if your captain and your crew member read that and understand it before they even get involved in joining their next ship, then they will know exactly what they should expect to happen in terms of the way that well-organised disciplinary procedures go. And it will explain, you know, the whole issue of summary dismissal, what constitutes summary dismissal. As we all know, lots of people get fired on yachts for things that are, in many cases, entirely unlawful reasons, but it happens all the same. So
For example,
I would urge, because the stewardess is more attractive than the boss's wife, and the boss doesn't like that.
Gotcha.
You know, or
the boss's wife doesn't like it.
Or the yacht manager just doesn't like you, even though you're the best employee on board, and they just, whatever, you know, it happens all the time. But, you know, being forewarned, be forearmed is good with a lot of these things. So I would urge everybody to read that document thoroughly, because, again, it's a two-way thing. It explains, you know, how their behaviour on board should be, the crew member. But the most important thing about it is it gives you extremely good guidance on what should happen in any kind of disciplinary situation. And depending on what flag you're on, if you're on, you know, shall we say, one of the more civilized flags, a red ensign, whatever, then that is an extremely good document to have knowledge of, because you will know straight away if you've been dismissed in a way that does not conform to what is laid down in the Merchant Navy Code of Conduct. Okay. Now, it may not specifically apply to your flag, but as so much of what happens in yachting, you know, comes from the UK jurisdiction, and still approximately 70% of the world's yachts fly a red ensign in some format or other. Okay, so that's an extremely good document to have, a reasonable working knowledge of.
Okay. Can you get them to equally sign it out of interest? I mean, you said you added on as...
It becomes a constituent part of the employment contract.
Okay, so therefore, including it into your contract, it doesn't they don't necessarily need to co-sign it 8 times, but it is included in your contract. So if there is some, or can I presume if there's some sexual inappropriateness or something that is not comfortable for you, you have it included. And so if you do then have to go back to Nautilus and say, I've had this issue and I included this in my contract, it just gives you a bit more of a kudos.
Yeah, well, what I do is I append it to the contract, and when you sign the contract, you are both parties, very importantly, both parties are agreeing to abide by the Merchant Navy Code of Conduct. That means if I have an issue with a crew member that requires any kind of disciplinary action other than, you know, a quick chat over a coffee, I, as the master, will conduct those disciplinary proceedings exactly as they are laid out in the Merchant Navy Code of Conduct.
Right.
And you, the crew member, will also agree to, abide to behave according to what is discussed in the Merchant Navy Code of Conduct.
Out of interest, just bringing our topic from last week, which was the MAIB, does in the Code of Conduct, do they have anything about incidences on board? Is that
in terms of what?
There are more accidents.
If there was an incident on board and they're looking at who's responsible or who was in charge at that time, is that involved at all in the Code of Conduct?
No, it's it's literally about behaviour on board and disciplinary procedures is the kind of the thrust of it. So again, all crew members should be very familiar with that document. And as I say, of course, it doesn't always apply. It was based for UK ships, but because so many yachts are registered on the British registries as well, a lot of them will be run in a civilized and professional manner, and that will be a document that employers and captains should be going to for guidance if they want a clear and approved by I said by Nautilus, by Chamber of Shipping, and by RMT, another union. So everybody knows where the goalposts are if you operate according to that code of conduct. So it's a really simple way to keep things in a format that has been tried and tested and approved by various pertinent organisations. So get familiar with that document, and it really is very, very worth reading, because you'll understand a lot more about the disciplinary process. I've got one other thing I'd like to mention before we get into a sort of list of top tips. Again, lots of garbage written out there on social media, and people shouting that the minute that a yacht owes you some money, you must arrest the boat. Well,
or chain the boat, isn't it?
Yeah. Well, let me tell you from personal experience, and I'm sure a lot of people will be aware of this as well. In most cases, arresting a boat is quite a complex process, up to being a very complex process. It's a very serious undertaking, and it can cost you personally a substantial amount of money if it goes wrong. Yeah. I saw you posted the thing earlier today about the equanimity thing. It's
just a soap opera.
That in almost all circumstances, once you arrest a boat, you become responsible for it.
Oh,
therefore, that's why equanimities run up a substantial bill.
So if it's arrested for, say, a month, and the cost of that boat for that month is €1 million, and it goes horribly wrong for you, you could be liable for the
potentially cost. You're liable for. Now, obviously, it depends in different jurisdictions, again, et cetera, but just in general terms, the point I'm trying to make is you can't just go along and arrest the boat. It's not a simple process in most circumstances, in most countries, and you are potentially opening yourself up to significant exposure to risk and financial disaster if you try to do this, and it's not fully justified. And again, you obviously need to be approaching competent lawyers that are competent in the jurisdiction as well. But there's so much nonsense that you read about. Just get the boat arrested. It is not that simple. It really is.
It's not just through social media, because I remember in France, and the amount of people that you talk to that did a job on a boat, and the boat was refusing to pay them. And excuse me. And the advice that would be dallied about, in the bar was, go to the douane and get the boat arrested. If it's over €7,000, then it's worth your while. And none of them ever said, well, you know what? If the boat had a good reason not to pay you, you could be liable for that.
Exactly. Yep. Exactly. Look, I say, I'm talking very generally here. I believe there are some jurisdictions and some circumstances. I randomly, personally witnessed a boat being arrested in STPR down in Palma years and years ago. The Guardia Civil just rocked up and boom, the whole thing was done in 5 seconds. But I don't know anything about the history behind it. I believe in certain jurisdictions, in certain circumstances, it's not that complicated, but it is not something that you want to enter into without fully understanding what you're getting into, the potential liability that you're bringing on upon yourself.
If it all goes horribly wrong.
When it all goes horribly wrong, yeah. So just be very, very cautious about that. Do not underestimate how complex it is to do that, and you should always try and seek some, other form of resolution first, if that's a possibility, which it generally is.
And for that, we go back to the first thing of make sure you have a good lawyer.
Yeah, when things have gone wrong, you need to be seeking legal advice. One way, of course, to do it is to be a member of an organisation like Nautilus. They can, if you're a member, they can provide you with legal advice, where appropriate to look at your circumstances.
Yeah, and they can forewarn you that you're not on solid ground here. So
yeah. With Nautilus, I mean, you can contact them whenever, and anything that's going on board, you can just contact. As a member of Nautilus, you can contact them and say, "Look, this is what's happening. Can you advise me as to what I should do?" And you're not necessarily going to get an instantaneous response there and then, but they will get back to you as soon as they can with someone who's competent in advising, whether it be a legal issue or whatever that you're dealing with, or it might be a maritime issue.
You did say earlier on that if we could just make sure we got 10 minutes for you to go through a bullet point. We're pretty much at that 10-minute mark.
Yeah, no, I'm watching
flies by, doesn't it?
It does, doesn't it? Yeah. Okay, yeah, I'll just rattle through these. First of all, prevention is better than cure in all circumstances. So get a copy of your proposed contract before you join the boat. Read it thoroughly. Query any points that you're unsure about in writing. Check with a competent person if you're still unsure about anything. It may be benign. Maybe you just don't understand it. It may be absolutely benign, but it may not be. So take proper competent advice if there's anything you're unsure of at that point, and then only sign the contract if you're completely happy with it.
And get them to, any changes they make, to get them to put it in writing.
Yeah.
Let's say I'm a young green crew member. I'm looking at my first contract. Where do I find a competent person to advise me? Do I go to Nautilus or?
Well, if you're already a member of Nautilus, then yes.
Yeah.
So,
if you're not, join.
Yeah, I was going to say, and if you're not, maybe it's a good idea to join Nautilus too.
Yeah, possibly so. Yeah. Look, I mean, contracts. Okay, seafarers' contracts are specific, but anyone that's generally familiar with the structure of a contract should be able to advise in general terms. But if it's anything specifically relating to seafaring, I would suggest that you go to someone who's familiar with the maritime side of the legal world.
Maybe the crew agent, if you're getting the job through an agent, maybe they give advice.
You could probably ask, if you've got a good, competent, experienced crew agent, they will be aware of what a standard SEA looks like. So if they see considerable deviation from a standard SEA, then maybe they could point that out and say, well, this is quite a deviation from what's normal.
Yeah,
which doesn't necessarily make it bad.
No.
But it just needs to be checked.
You need to understand
because it has deviated from the standard format. Yeah. I would say if an employer is not upholding their side of an agreement, don't waste too much time in trying to resolve it. Personal experience has shown the longer it goes on, the worse it gets, the deeper the hole is. Yeah, okay. If you can't get it resolved fairly quickly, cut your losses and move on. Would be my advice.
Mm-hmm.
Uphold your end of the contract. Yeah, very important. It's balanced. The contract is there to lay out what both parties' responsibilities are, and both parties are expected to live up to their side of the contract as well.
Plus, if it goes to litigation, you want to be on solid ground.
Exactly.
If you're not living up to your side, well, you don't have a great argument.
Another thing I've come across quite a lot in the past, people have signed up for like a 1-year contract. Well, to be honest, a contract is really only as long as the termination clause in that contract. If you have a termination clause of 30 days and the employer has reasonable justification to terminate your employment, i.e. the boat's being sold, they're going down to a skeleton crew, whatever, then though you've just signed a 1-year contract, it's really only good for the period of the termination period on it. Educate yourself. Read MGN 447. Download a model format SCA from the MCA website and read the Merchant Navy Code of Conduct.
And attach that onto your contract too, as you mentioned earlier.
As an employer. That's what I've done that for many, many years. As an employer, I've said, right, this is part of the contract.
Okay.
It just keeps things really, really simple.
As an employee, say if as you're a captain, I'm looking at a job. You give me my contract, and I come back to you and go, okay, I'm happy with the contract. However, I would like to add on to this the MNCC as an annex to this contract. Would you, as a captain, think, oh, you're a troublemaker, or would you go, okay, that's acceptable?
Well, for that particular thing, they wouldn't have to, because it would be included in anyway if it was a contract I was writing. Yeah, because it makes perfect sense to have it there.
But say a non-Ian Flockhart captain, a captain that wouldn't have it in normally.
I think a lot of employers and a lot of management companies issue very, very Spartan and simple, straightforward contracts that are, as I say, the ones I've seen, I'm not impressed with them at all. But that seems to be very standard within the industry. If you've got somebody that you think's worth employing and they're asking, even before you hire them, for something extra in their contract, if you feel it's justifiable, then it can be incorporated into the contract. Yeah,
or again, if you clarify your reasons, just, I think this
don't
is...
Don't be afraid to ask.
This is a good thing for us all to include. This is my... I've been giving good advice, and this is what I feel is helpful to both of us to make sure that conduct is carried out as should be.
Okay, carrying on. Be cautious of flags of convenience. They exist for a reason. Okay. Multiple jurisdictions, we kind of discussed that, my nightmare scenario where you've got, 4 possible jurisdictions there. Just back to the Merchant Navy Code of Conduct a bit. Read the bit specifically about what justifies summary dismissal, because a lot of yacht crew are summarily dismissed where it is entirely unlawful. Not an easy thing to deal with on yachts, but it does happen. And all I'm saying is at least be aware of what constitutes summary dismissal. Okay. One from personal experience here. If you're already employed on a vessel and the employer wants you to move you to another vessel within their fleet or family or whatever, make sure that your existing, either of the following, make sure that your existing contract covers that eventuality, or make sure the contract is amended to reflect the move to a new vessel, including the name of the vessel. And if the vessel has changed, it's entirely possible that the employer has changed as well. Make sure all of this is reflected. Or get a completely new contract written to reflect the new changes, the name of the new vessel, and or if the employer is new. Even if you're working for the same owner or the same family, the boat might be owned by an entirely different entity. And if you end up with a dispute at the end of it, you're going to be on very thin ice because you actually have no proof that you were working for that particular vessel employer. Yeah. Okay. And don't allow changes like this to happen on a handshake from the owner or the representative.
I think, unfortunately, in our somewhat more litigious society, a handshake is really no longer sufficient.
No, it's not. Because, say all of this stuff's fine until it goes wrong. Oh, but I've worked with him for 5 years. Yeah, well, maybe all of a sudden they don't have as much money as they used to. Yeah, and your personal bitter experience from me in that situation. Couple more, just again, we've said this, but seek competent and relevant, i.e. through jurisdiction, legal advice at an early stage if you feel it's necessary. And finally, just don't work on a boat without a written contract.
Yeah, bottom line.
Yeah, that's it. There are so many potential risks to you, and it also tells you something off the bat about the person you're about to go and work for. If they don't have their act together enough to be organised enough to have you a proper contract of employment in place before you come to join the vessel, you really should be looking elsewhere.
Well, and they obviously equally, you have this massively expensive asset. You want to make sure that the people on board minding it and taking care of it are people you can trust. As you said in the start, it goes both ways. So it's not just for your own protection. It should go both ways.
It should be setting massive alarm bells ringing if, an organisation that has, a substantial amount of money behind it can't even get their act together enough to prepare you a proper contract of employment in advance of that. You should be worried.
Well, a lot to absorb there. I think we're going to have to put up a new page on our website for links to all these documents. So we'll talk to you about that later. No, I kid you not.
Crew advice.
You've been listening to it.
Well, I'm working on that already.
Well, I think we need it as well.
Thank you so much, Ian.
Thank
it
you.
was super to get your knowledge and wisdom on this.
You're very welcome.
And we will catch you again.
Captain Ian Flockhart, many thanks, and we'll talk to you soon. You're listening to Superyacht Radio.
Thank you.
Top of the hour, time for the news.